going to be more coming. We do have another case coming to you soon. They're picking a jury today in Iowa. This is Iowa versus Whaley, Larry Whaley, who is accused of killing, what is her name? Samantha Teeter, I think. Samantha Teeter, that's Samantha Teeter right there, 19 years old, a beautiful young lady, was in the hallway and apparently was shot through a door and killed. She didn't die right away. She was taken to the hospital. He was first charged with attempted murder because she didn't die, and then later charged with first-degree murder. He seemed surprised that he was charged with first-degree murder. He kept responding to that even in court and saying, first-degree murder, I was defending myself or something. So it's going to be so interesting, Jonna, to your point earlier, how the mental status of this defendant plays into this self-defense claim.
That interplay is going to be and it not only is it going to be interesting, but it's going to require expert analysis for sure, which then, whenever you have an expert on one side, you're going to have an expert on the other side to say the opposite things. And, oftentimes your expert's going to say what you're paying them to say. I mean, that's the criticism of experts. I don't personally believe that. I believe experts are an integral part of the process when you need them. But it will most likely come down to that.
Without a doubt. In fact, in the competency hearing, the prosecutor had two different people investigate. I would assume interview him. Mm-hmm. There was John Bales, who's a neuropsychologist or psychiatrist, and Arnold Anderson, who's a psychiatrist, who both testified that he was competent to stand trial.
Right.
Now, let's talk a little bit about that, because a lot of times I think that the layperson will say, well, then if he's competent to stand trial, then he's sane.
Right.
But that's a different standard, right?
Standard.
Yep. Yeah.
Totally different
so
standard.
it's, the issue of his mental status certainly can and probably will come up at this trial. Mm-hmm. And then I think we would see defense experts as well who are, testifying as to whether or not he's able to actually, because, we've covered a lot of self-defense cases, mm-hmm. and it's whether or not the belief that you were in danger is reasonable. And how does that play if the person is not in the right mind?
So will it come down to, is it reasonable, like the eggshell cases that we learned in law school? Will it come down to that sort of analysis? What's reasonable for me as a hopefully sane person might not be reasonable for somebody like him who has some issues, but is competent. Because as you know, competent just means you can understand the proceedings and you're able to participate in your defense. Yep. Has nothing to do with whether you're sane or insane.
And whether or not you know the difference between right and wrong. And it actually is a great segue. So later on this afternoon, when Aaron's here, he's going to be playing some clips from way back, practically when Law and Crime started, and that's the Curtis Reeves case. And the Curtis Reeves case was an older gentleman who was a retired police officer who shot and killed someone in the movie theater. And part of what played into his case, he put forward a stand your ground defense.
Oh, that's right.
And in front of a judge, and it was a long hearing, and I was actually hosting on the days that he testified, and I was fascinated. And then she put forth an order, like at the end of that week, where she said that the stand your ground defense was not applicable and that he was going to have to stand trial. Now, this case is on appeal, and the appellate court is looking into it. If they determine that the stand your ground defense does apply, then he is a free man.
Wow.
If they say no, then he's going to have to go back to trial. And then this is in Florida, where the standard has changed. The burden of proof has recently changed. So there's a lot of legal issues that Aaron's going to be getting into this afternoon. Be sure to tune in to Aaron's conversation on this. But to your point about the person themselves, one of the arguments in this case was it's not a big, strong man whether or not their fear was reasonable. It's whether or not an older gentleman who's seated while someone is standing over him and who perhaps doesn't have good eyesight, and how do all those things play into the reasonableness? And whether it's a woman, whether it's an African American, all of those things, sort of go into each person's individual perception. Right. And how much can a jury or a judge get in one person's head?
I think that's
not
very
easy.
difficult. I think that's extremely difficult. And one of the things that we know is that a jury is supposed to be a jury of your peers. But let's be truthful. When you're doing voir dire, you take what you get, right? So a lot of the times it may not necessarily be a 12-pack of individuals who are his peers, his or her peers.
Right. Yeah.
Yeah, these cases the self-defense cases are always fascinating to me, and I do think that Larry Whaley has an uphill battle here.
Oh, absolutely.
But it'll be interesting to see, and his defense altogether will be interesting, because I do think he's not going to be able to help himself but to pipe up. Have you ever had that situation where you've had a client who's wanted to? Looks like Jonna has.
Too many times. We don't have enough time on this show. Yeah, but that happens, and you know when it happens most especially is when you have a client who just insists on their, quote, innocence. And I'm not saying that they're not, but they think that the more they talk, the more they'll be able to convince whoever needs to hear it of their innocence. And when they don't realize that a court of law has strict rules for a reason. And we have jobs for a reason. Let us do ours. Let us do our job.
Yeah, well, and but at the same time, you do understand where these people who it's their life, their job, their money, their crime, they're the victim. Right. And, you know, just this morning on Law and Crime, I don't know if you guys were all watching, but they showed some victim statements. And when you watch those, you realize, you know, these people want to use their voices. They want to be heard. In fact, it was very frustrating because this was in the Jeffrey Willis case, I think. And he left. He refused to stay for the victim's statements. And some of the victims were saying that they were especially upset that he was not there to hear them. Right. And I think that happens sometimes with our clients, that they want to be heard. Yeah. And we, lawyers, are sometimes nothing more than mouthpieces for their clients, and sometimes they don't like the way that we're saying that we're using our mouths.
But you know what I tell my clients in that situation, I would say to them, listen, I would not endeavor to pull my own tooth or to excise my own brain tumor for a reason. I don't have the expertise to do that. You do not have the expertise, unless I'm representing a lawyer, to know the strategy that needs to go into this to put you in the best possible position to get the outcome that you seek. Right. So sit down and shut up.
But even sometimes us as lawyers, when we need representation, sometimes we want to, you know, throw in our 2 cents, but at the same time we can't be objective. So it's even for us, it's time for us, like as you said, to shut up and let the other person do their job.
That's why there's that saying, the lawyer who represents himself as an idiot for a client, or something like that. I mean, it's certainly not something that you should be doing on your own. And you're right. I mean, I think Larry Whaley, you know, he's written enough letters. He's fired one of his lawyers. It was a state public defender, and another lawyer has stepped in. So it's going to be interesting to see how this trial goes. This trial that we're talking about, Iowa versus Whaley, starts tomorrow, hopefully. They're picking a jury today. If all that goes well, then we will start at 9 o'clock tomorrow morning. I think it's Central Time. So we will have that live for you here at the Law and Crime Network. And I do think it's going to be an interesting one to watch. In the meantime, today, as I said, a little bit later this afternoon, Aaron's going to be talking a little bit more about the Curtis Reeves case, and we'll have all the latest in the appeals process there. Today, we're talking about the Dobson case that we watched last week, but since we had 2 trials going on, but we weren't able to cover the Dobson case with as much depth as we had hoped. So we want to continue the testimony of Larry North. He is one of the friends of the defendants and involved with this whole YouTube video that we've been talking about with Stephanie here and Jonna here today. We're going to go back to a clip of him, and we'll come back and talk a little bit more about the Dobson case.
Are you saying that you don't remember saying those things? Is that what you're saying?
Yes.
Okay, but you heard yourself say those things, right? And so your answer is that doesn't refresh. Okay.
Okay, sir, if we could, I want to go back to see if I can refresh your recollection with your prior reported statement to the police.
Your Honor, respectfully, I think the question first has to be asked before we put a recorded statement up is, do you think it can be? You don't get the opportunity to do it. I get it's, you know, perfunctory, but he has to at least have the opportunity to answer the question.
You asked that earlier about the text messages, and so since we got the jury out hearing, I'm not going to make her do that in front of the jury. If it does, it does. If it doesn't, it doesn't.
Well, my thing is once you play it, you've already suggested it. I mean,
but
I think
the
at least
jury's
that's
not seeing that. He would get to read it anyway. It doesn't matter. So I'm going to let him refresh his memory if it does. If it doesn't, then it doesn't refresh his memory. I'm going to let him at least show it to him, which is, that's the way the rule works.
Sorry, I had asked you the question about the names of the people who left out of the apartment or who arrived at the apartment, and you did not recall. I would like to play a portion to see if it helps you refresh your recollection.
I seen 3 people come in the house. They didn't want to came over there to my sister's house in the Green Hills or whatever. Next thing I know, they stayed for like.
And who are they?
Well, the one, well, Brandon, the one got shot. His cousin Chris Bassett. What's his name? I think Kip was with him.
Who's Kip?
Carter. Yeah.
And the
No, it keeps.
were you able to?
Yeah. And Richard, he was out there on the same somewhere, yeah, whenever he came to the Green Hills, but yeah, I guess I didn't.
Okay. And let me play you one more clip. On the issue. Let me.
Tell me the truth. Tell me everything that I'm not saying. And I promise to God on that.
Who was in that car when they left?
I honestly think they were in 2 cars. And, of course, Brandon, the one, mom got shot. Chris Bassett, the one I got in there. That's his blood cousin. Killed. Let's see, Richard. I think that was in one car. Another car. I can only say one person. It was probably Malik.
Malik what?
George.
And what kind of car were they in?
He brought like a gold Cadillac.
Gold Cadillac? 4 or 2 or?
4.
How many people altogether?
Well, with me not knowing how many was in his car, I say 5.
At least 5.
At least 5.
Do you know if any more went?
I'm sorry.
Okay. So at least 5 people, 2 cars.
At least 5 people, 2 cars.
Now,
They ran into the building and then that gold Cadillac.
was Malik wearing all black too?
I know he had on black hoodie for sure.
Okay. How many guns did you see?
Yeah, we need that too, because you didn't remember where they went, right? So let's go down to right there. Right above, are they in the gang? So where did you start?
Where did I start?
How many guns did you see?
Black hoodie for sure.
Okay. How many guns did you see?
Sorry.
Black hoodie for sure.
Okay. How many guns did you see?
I'm saying they probably all have one.
Each one? At least 5.
At least 5.
Are we talking handgun or are we talking long gun?
Oh yeah, handgun. No only they not protected. They feel like they can't carry assault rifles and nothing. Can't do too much with that carrying it around.
Right. Don't know exactly where they went, but they went somewhere on the west side.
And like when I say west side, they just feel like probably like Western Heights, Lonsdale,
Now, sir, were you able to hear? I think there's one more, Phil. The 9 o'clock. Yes. Let's do like the line before.
They didn't want to talk about this. We just started listening to music. And when they said 9 o'clock hit, we leaving. I don't know what time they came back, but they said 9 o'clock, we leaving. We about to go hit the West. I hate to say all this about people I consider my brothers, my family, because I kind of feel like I'm snitching, but I'm not. I just don't want myself to be in it.
So, sir, were you able to hear those clips that we played? And after listening to those clips, do those clips help to refresh your recollection as to what happened? About the questions that I was asking you about who left out of the apartment?
I said that right there, but I don't know. It's nothing like what 3 years ago.
And so even after watching these, well, let me ask you this. After watching that clip, does that help to refresh your recollection as to the time that they said that they were going to leave?
I mean, yes, at the time, right there.
Does that help to refresh your recollection as to the time they tell you they were going to leave?
No, I like that. No, I'm not sure.
Okay. After watching that clip, does that help to refresh your recollection as to the location where they said they were going to go?
Yeah, I guess.
Okay. What location did they say they were going to go to?
West.
Did they specify where at West?
No.
After watching that clip, does that help to refresh your recollection as to where West they were going to go?
No.
And after watching that clip, does it help to refresh your recollection as to whether or not you saw any guns?
No. I mean, I said everyone here on. I don't remember that.
You say you don't remember that now?
I don't remember everyone. I don't know.
And just so we're clear, this statement, it was video recorded right after your cousin being shot.
Are you saying that you don't remember saying those things? Is that what you're saying?
I guess so.
Okay, but you heard yourself say those things, right? And so your answer is that doesn't refresh?
Refresh anything.
Okay. You just don't remember saying those things, even though you've heard yourself say those things? Okay. Judge, I don't have any.
So you originally said you didn't think Kip came in. You said you didn't think Kip came in. Do you recall saying that earlier?
Yeah.
Okay. You recall saying it?
I just said yes.
Okay. Okay. So you don't think Kip was there? I'm sorry, what's your answer?
I don't know.
You don't know. Okay.
Judge, I apologize. I assume we were just crossing the words.
Okay.
Yeah, we're just talking about the
Okay.
specific statements. It was about who left together in the cars, who had guns.
Okay.
How many guns.
Who had the guns? Do you recall saying that? You don't remember who had guns?
No.
Okay. So you don't recall if Kip had a gun?
I didn't like people being the same stuff.
Just one last time, okay?
No.
That's all.
Mr. Jones, any cross at this time?
Yes, Your Honor. I think it directly follows under Crawford versus Washington, it's a United States Supreme Court case. It's testimony.
We're not arguing.
Okay. Oh, I'm sorry. I apologize. I'm just all fired up, aren't I? You simply just don't recall. Is that fair enough?
Yeah, man, this stuff happened so a couple years ago. I'm trying to forget all this.
Right. Even after seeing this, just
Yeah,
not a lot of it.
I heard what I said, but she asked me if it refreshes anything in my memory. No, it don't.
Anything else?
No, Your Honor.
All right, Mr. Rogers, your position as to admissibility under 80326 is substantive evidence.
Is I don't have the rule. Is it for impeachment?
No.
Impeachment.
613 is for a prior inconsistent statement. And what the state is attempting to do is to admit a prior inconsistent statement for substantive evidence, not as to attack his credibility as a witness. So they want to bring in these clips as proof of what happened at the time. And there's certain safeguards that have to be met. It has to be a prior inconsistent statement. The court does find the statements that have been played here are inconsistent with his testimony here today. It also has to be a recorded statement, which it is. And the last part is, during a jury out hearing, by preponderance of the evidence, is that prior consistent made under circumstances indicating trustworthiness. And so that's really the issue that we're arguing here.
Right, and my argument would be that you're trying to refresh his recollection. He's continuously saying it's not refreshing his recollection, although he's not denying saying those particular things or hearing himself say those particular things.
Right.
I think to end around the testimony by playing a prior statement would be prejudicial and it takes away from his testimony here today. And so I think that the reliability of the statement given at the time, especially when he's saying certain things under duress, talking about possibly being called a snitch, also being on the scene of several places and possibly being a suspect maybe in his mind, that the reliability of his testimony today under oath in front of a jury is more reliable than the statement that he gave to an officer when he was trying to protect himself.
All right. Mr. Jones, what do you say?
Your Honor, I think the court's got a problem primarily under Crawford versus Washington's United States Supreme Court. I'd direct the courts to that. I'd ask you to look at that.
They may have a problem.
Okay, I got you. Okay, I apologize, and I did not mean to impute that, okay? That being said, 541 U.S. Supreme Court 36, literally almost duplicious set of circumstances relative to a stabbing and a rape of a wife, and basically it violates the defendant's constitutional right to cross-examine because he cannot cross-examine that recorded statement, and it's inadmissible under that set of circumstances.
But it's right here.
I understand, but it says that you can't. I mean, I'm not the one who authored this, Justice Scalia.
The witness didn't testify, though. Did they just claim?
Well, at this point in time, he said that he doesn't recall relative to that. So to allow this to go in where he wasn't subject because it was recorded in anticipation of a legal proceeding. There's no question that Detective Leffler or what other personnel with the Knoxville Police Department were anticipating a legal proceeding relative to what had been going on relative to this particular recordation, Your Honor. I would ask the court to at least take some time and re-glance back at that before making that decision.
Thanks, sir. All right. Ms. Lee, did I let you argue?
No,
I'm sorry. Go ahead.
I agree with Mr. Jones.
All right, very good. General, anything else you want to say?
No, Your Honor, we believe that the prior inconsistent statements, we believe that this is a situation that this case is made for. Clearly, this victim, he is reluctant. Your Honor can take it. He is scared. He can say that he's not, but we believe his body language shows that he is. He is wearing sunglasses while he is testifying. We believe that the statement that was given to the police that night, we believe that it appears to be credible. He is someone who is trying to tell the police what's going on. He is trying to be helpful with the police. We believe the circumstances in which he gave the statement to the police indicate trustworthiness. We believe that under 803.26 that is admissible.
All right. So 803.26 was added to our rules of evidence not too long ago, really for situations exactly like what we're faced here today. Normally, a statement that's made outside of court is hearsay and is inadmissible. Prior inconsistent statements can come into evidence at times in order to attack the credibility of the witness. So if they said something in the past that's different than what they're saying on the stand now, you can bring it in not as substantive evidence for the jury to consider, but as evidence to consider whether or not they're telling the truth on the stand here. 803.26 goes further than that, and it allows prior inconsistent statements to be admitted for the substantive evidence of the truth asserted in those out-of-court statements. And as I was mentioning, there are certain safeguards that the court has to follow. One is the declarant has to testify at trial and be subject to cross-examination concerning that statement. And that obviously is what's going on right now. And I think that defeats Mr. Jones' Crawford argument. The Sixth Amendment issue that you have with these out-of-court statements is one of confrontation. And the person who made that statement is here in court and subject to cross-examination. So I don't think it's a Crawford issue, Sixth Amendment issue. The statement is, in fact, video recorded, which we've seen as audio that we've played portions of that today. And as I said, the really issue before the court is whether or not by preponderance of the evidence is that prior inconsistent statement made under circumstances indicating trustworthiness. The court does find that it does. Mr. North said today and to the police at the scene that he was going to be the one to talk to the police because he was so upset with seeing his cousin dying in front of him. And so it's kind of like an excited utterance. When somebody is in an emotional state like that, they tend to tell the truth about what has just happened. And this interview occurred right after it happened. And shortly, almost immediately after speaking to the police, Mr. North was allegedly shunned by these individuals and was subsequently shot for speaking to the police. We heard that testimony somewhat today, but in much more depth during the first trial when Mr. Williams was accused of shooting Mr. North. And so I think that the statement that Mr. North gave to Investigator Leffler by preponderance of the evidence does indicate that it was a trustworthy statement that he gave at the time. More so, I believe, than the statement that he's giving here. So I'm going to allow the state to introduce those portions that they played under 803.26 as a substantive evidence. And now, generally, you will need to put that on a separate disc because the instructions that I'll give the jury is they cannot consider any out-of-court statements for their truth of the matter asserted unless entered as a numbered exhibit. So you're going to have to give an exhibit number. All right?
Yes, sir.
Welcome back to the Law and Crime Network. We're continuing to watch clips of the Dobson trial, and we were sitting here talking about how sympathetic this case is. I mean, you know, in cases like this one, Jonna, where you've got such a likable, admirable young man who was killed protecting these young girls, is it just an uphill climb for defense? And is it possible to really get a defense verdict in a case like this where they need to have someone to blame?
Well, you know what, I'm strange in that I think that any time an innocent life is lost, even if it's not heroic as this, I always think that's just a crying shame, right? So in a case like this, of course, the prosecution is going to, weave in the fact that this kid was really so young and his whole life ahead of him and being a hero at the time, and that makes it worse. And where that plays in my mind is, I would have been trying to get a deal from day one in a case like this because you really don't want it to go in front of the jurors. Jurors don't have to be as discerning. They do think with their hearts, even though they're instructed not to.
Well, it's such a difficult thing. You know, it's one of the things that I was listening to the charge to the jury in this last case, and they talk about sympathy cannot be part of your evaluation. But we're talking about human beings here. What do you do with that, Stephanie?
I mean, that's very difficult, and it's something that we see every time here, or something that we take into consideration a lot when we're, analyzing these cases.
Right.
The emotions, the hearts of the juries, will they come to play? And we saw that in Holly Bobo, we saw that in Jessica Chambers. It's something that, let's be real, cannot be avoided. We tell the members of the jury, you have to stick to the law, but in the back of our minds, we know and that's particularly the reason why we pick certain members of the jury, because we know they may be somehow emotionally tied to the particular case.
Well, and a lot of people earlier today, when we showed the Dylan Adams hearing and talking about plea deals, and a lot of people were getting frustrated that, why have plea deals? Why not have trials? And we were talking a little bit about judges and their dockets and all of that. But another reason for plea deals is because it protects the defendant from the sympathy of a jury and may actually, a lot of times these deals are good for everyone involved. The victim's family doesn't want to deal with going through another trial, say, for example, in the Holly Bobo situation. And Dylan Adams bears the risk of serving a lot more time than he could probably get in the deal. So, taking that sympathy piece, you cannot take it away. You cannot take it away in the Dodson case. You cannot take it away in the case that we're starting tomorrow with poor Samantha Teeter, this young 19-year-old girl who was doing nothing more than walking down the hallway. And so, plea deals are oftentimes a good thing for both sides to take away the unknown of a trial. And one of the things I sort of constantly ring this bell here at Law and Crime, litigation is so stressful. It is. It's so stressful, not just for the lawyers, put that aside, but for the parties, the victims, the people who are on trial, civil or criminal. I mean, there's been studies shown that it has a huge impact on people's health. A lot of people die after litigation. And so when you can come to an agreement that every side is at least kind of happy with, it's not a bad thing.
Nobody's going to be permanent. The interesting thing is there is no right to a plea deal. You could have when you're representing a defendant, you could have one who wants to sign up and say, give me some sort of deal. You don't have a right to do it. And if a DA doesn't want to do it, your client ends up what we call pleading to the sheet, which is no deal. That's just admitting every single charge that you're guilty of, or that you've been charged with, I should say. And so there is absolutely no right to that. But you're right. More often than not, it's the best outcome.
Yeah, for everyone involved, which is sort of hard, especially for trial watchers, to wrap their arms around that, because it just doesn't seem fair, and it seems sort of contrary to the way the system's supposed to work.
Well, I'll play devil's advocate a little bit here. Yes, agree with you. Sometimes a plea deal is the best way to go, but then you also have those situations in which a person is claiming their innocence and they do not want to take the deal. And then you have a judge who will admonish the defendant and say, look, okay, you want to go to trial, but yes, if you go to trial, that plea deal is off the table.
Wait, you just tapped into something else that really burns my behind. Because this happens in real life way too often. When you have a client who is exercising his or her right to go to trial. You have a constitutional right to go to trial. And a judge says, okay, but if you avoid the plea deal and you go to trial, if you are found guilty, I'm going to give you a far worse punishment
that's exactly what
than if you pled. And that's like, you can't do that. But they do it.
Yeah, then that's to the point, I think, of a lot of our chatters today who are frustrated with the last Adams hearing, because that is manipulating the system, and it's judges who don't want to. Because the other thing about a judge's job, and a judge's job is a very difficult job. You know, it's not easy to make these life and death decisions, especially if you're the one deciding the facts as well. But one of the judge's jobs is not to get overturned in appeal. And if you enter into a plea deal, there is no appeal of that for the most part. And so that also avoids sort of that whole idea that any of my rulings at trial could be overturned. And so, you know, judges are people just like lawyers and just like, the victims and defendants and prosecutors. And so it's definitely something that is to be considered. And it's a really good point, Stephanie, that, you know, if a defendant wants to exercise their constitutional right to a trial, they certainly should be entitled to do that without any
additional punishment.
Punishment within the system.
And even if a judge intends to do that, don't say it out loud. Your job is to be unbiased, fair, and impartial, right? So, I mean, if you're going to do it, then I suppose just do it. But wait at least until all the facts come out, because a judge will know a little bit about your case before a trial starts, but they don't know everything on purpose, and you don't know how. You probably haven't heard the defendant testify to anything, unless there was a pretrial motion and he did, but they should just reserve that judgment call until after the trial.
It reminds me a little bit of the conversation we were having before. People in positions of power can sometimes abuse those positions of power, and not because when a judge does that, Jonna, and it does happen, do you stand up and say, that's not right and I'm going to report you? But I
actually have done that.
Of course you have. Because you have got confidence that everybody could learn from. But I think that for a young lawyer, no way a young lawyer is going to take on a judge.
All the time.
And but it's this position of power. And I think that power can get people who go into a certain position, whether it's a movie producer or a judge, who want to do the right thing. And then power can sometimes, you know, if it's not countered with good conversation and communication and people challenging them like you have, it can be dangerous. And I feel for the young associates, young lawyers, men and women, who are in those situations and don't have the guts to speak up to it.
It takes a while to build. Can I just say a really quick funny story? My very first jury trial, very first one, 100 years ago in California, and it was a civil case. I had the judge in that case stop the trial, took me back in chambers, grabbed me by the arm, and said, "Stop objecting." Stop objecting. And I stopped objecting. And I said no, and I did it. I didn't. And it was. I mean, a little nerve-wracking, because then I was just pretending to have confidence. Now I actually grew into my shoes. Then my shoes were like here, and my feet were here, but I did anyway. And I thought that was, looking back now, that was very unfair of that judge to do.
It's interesting to me, because because my first trial, a judge sort of gave me the eye, like, to object. Because I was doing the like up and down, like, do I do it? Do I want to do it? And he was like, you do want to do it. And he was wonderful, but for me that was just guidance. But this judge, we didn't feel like it was guidance. It was really just, you're being a pain in my butt.
Yeah, you're being a pain in my butt, and I don't want to hear you. And it wasn't like, in my own defense, it wasn't like I was objecting to every single question. I was objecting where I thought it was appropriate. And me and this judge, as you know, before you get to trial, you have conversations with the judge, and she wasn't really a friend, you could say.
Right.
So I was probably in for that, and maybe I geared myself up for that, but it was still very unfair.
Yeah, the only thing that I can say in her defense is that at least she did it privately. Because there are a lot of judges who will embarrass you in front of the entire room and the other lawyers and your client.
But hang on. Pulling me out of a crowded courtroom in the middle of a trial with the jury sitting there to give me a talking to, equally as embarrassing.
Yeah, just as embarrassing. You're right.
I've had a judge do that to me during voir dire. Actually, there was this particular judge in New Orleans while I was a prosecutor who just loved doing voir dire for the prosecution. So he would just,
voir dire is
lay
jury
it out.
selection. So when you're doing jury selection and you're asking the jurors questions.
Asking the jury, he'd ask all of the preliminary questions, and that's sometimes I like to do that because I like to have a rapport with the members of the jury or the prospective jurors. And I remember one day I was just like, you know what? To hell with it, excuse me, but I'm going to do this myself. And I did it, and he was furious. Like, you could see him, like the egg frying on the top of his head. And sometimes you just gotta give a little pushback in that courtroom.
It's not always easy.
No, it's not.
It's not. You get that shaky feeling inside, but it does grow confidence. The more that you do it, the more that you sort of feel it out and feel when you should be pushing back and when you shouldn't. And sometimes you're going to push back when you shouldn't be pushing back, and that's a learning experience as well. In this case that we've been watching, the Dodson case, I do think the defense attorney is very good, and it's fun to watch good lawyers, especially defending cases. So we're going to watch this last clip. Since I've arrived, we've been watching Larry North testify. We're going to watch this last clip, and then we're going to switch to a neighbor, and that testimony is a lot different than this. So first we'll finish this testimony, and then we'll be back to talk